Okay, and then on to our speakers. So David Garfield is the founder of the Garfield Law Group. He has over 33 years offering full immigration services, and he was recognized as one of the top immigration attorneys in the Washington, D.C. area by the Washingtonian magazine. Michael J. Freestone is a principal in the firm's immigration law group, where he advises individual and corporate clients representing a broad range of industries, including medical, software, steel, construction, aerospace, and religious organizations. And the full bio of these two gentlemen will be placed in the chat. The Garfield Group has offices in Washington, D.C. and Honolulu. And on a personal note, we've referred clients to Mr. Garfield, and all of them have been very, very happy. So we're very fortunate to have these two speakers with us today. So with that, David, Michael, why don't you take it away?
All right, great. It's great to be back. I think this is our 5th or 6th time that we've done this, and I really appreciate the invitation, and it's always an honor appearing with you. Also, I'm happy to introduce Michael Freestone, who's of counsel. As you know, we have a main office in Washington. I live in Honolulu. Actually, I live in Kailua now, and we have an office in Honolulu. But we're just so happy to have Michael Freestone as part of our team, and we work collaboratively on cases that apply a lot to your clientele as well. So just to echo what Patrick says, and I probably repeat this every year, is that, you know, when people are thinking about buying, investing from overseas, it naturally occurs that in some point, whether short-term or long-term, that they have an interest in actually living in that house. And therefore, we think it's helpful and to have some conceptual concepts of what types of visas they could potentially apply for. Obviously, you're not giving legal advice, but just to have that general knowledge, I think is helpful in guiding people to attorneys who can follow up on that option. And a lot of times, these are people who are highly skilled and have an incredible footprint in their professions, and they're not aware that there are options, short and long term, for green cards or even non-immigrant visas based on their exceptional abilities. So that a lot of times these concepts are not well known to the general public and to investors. Michael is going to do a lot of the presentation today, and I'd like to introduce him here. He's here next to me.
Thank you, David. Yes, it's very nice to be here and to meet everybody, and I'm excited to be working on this presentation. And I want to echo a lot of what David said. You know, we're the alphabet soup of US visas, non-immigrant visas, green cards. It can be a little daunting. I think we mentioned A visas at the beginning. Those are actually diplomats. We're not covering those, but it gives you an idea. We have visa categories from A to U. So we're only going to be focusing on the ones that are probably most appropriate, that people may know something about, maybe not a lot, but the guidelines that we can give certainly will allow you to give general advice. Obviously, you know, seek out an attorney that you trust for specific advice. But armed with this kind of information, you know, you can certainly give some general pointers about things to look for, potentially things that people haven't thought about when they're looking at coming to the United States.
Michael, you might want to move a little more center camera. You're a little blurred.
Oh, here we go. Yeah, there we go.
Okay.
Perfect.
Yeah, thanks.
Excellent. All right. Well, let's crack on in. Here's a wonderful picture of David, and there's a picture of me looking very smug with myself. But let's move on quickly. So just to go over what we're going to be going over, we're going to cover non-immigrant visas. So these are temporary visas to the United States, going from B to O. And then we'll be talking about immigrant visas. Specifically, these deal with green cards. And finally, we'll just go and do a little summary of, you know, the services that we offer. Going into non-immigrant visas then, and the key sort of concepts that we're looking at here, we've got non-immigrant visas on the left on this slide and immigrant visas on the right. In terms of non-immigrant visas, you're looking predominantly at temporary stay, visas for temporary stay for a specific purpose. They're usually obtained via visa application to the Department of State or via change of status petition or other applications internally in the United States. And I think one of the things in terms of an update of how things are going in the world, because in case no one had realized, there's been a global pandemic for the last few years, and also an administration that wasn't really focused on serving immigrant needs. There are a lot of delays in the non-immigrant visa process through the embassies worldwide. The Department of State, in their last briefing that I attended last Friday, are still on track to getting visa issuance back to normal by 2024. A lot of embassies are still behind on that, mainly because visa operations for the Department of State globally are tied to in-country conditions. So certain countries that are still experiencing high levels of restrictions, those apply to the embassy. That's part of their deals with the countries. So we're still seeing some delays in non-immigrant visa appointments. Immigrant visa appointments are also subject to delay, but we'll talk about that in a little minute. One thing to remember about non-immigrant visa appointments, so when you go to an embassy and talk to an officer, there is no appeal of those appointments. It is the consular officers have their final say, unless there is a specific point of law, in which case we can maybe do something about it. The first one of the non-immigrant visas that we wanted to talk about is the B1 visa. So I always like to point out B1 visas because they are really a key piece of evidence for entrepreneurs or investors coming to the United States. I think the embassies really like to see that an individual has a B visa, so that shows that they've come to the US. They've been looking for maybe purchasing property, setting up a business, something like this. B1s, however, are relatively restricted in what you can do. They are business visitor visas. You're really looking at business meetings, consultations. However, if you're an investor or an entrepreneur, setting up a company, setting up an investment, checking in on that investment, negotiating contracts, negotiating terms, things like that, that's all allowable on a B1. So B1s are definitely a tool to come to the United States. I mean, I think it's the embassy officials can look a little skeptically if maybe someone is looking to invest $500,000 in a US business if they've never been to the country before. And I would also point out ESTA visit, B1 is a form of, the ESTA is just a streamlined version of a B1. What you can't do on a B though, no direct management, you can't work, right? You can't receive income from a US source, and you can't go to school on a B. That's an F visa. We're not really going to talk about those. Generally speaking, B1s are issued for 10 years. And when you enter, you're given 6 months, up to 6 months by a consular officer when you come in. Customs and Border Protection, though, will probably limit that time. You don't really want to spend more than 6 months in a year on a B1, or Customs and Border Protection will want to know what you're doing in the US. Moving on to one of the more popular visas that people like to talk about is the H-1B visa. Now, it is probably of limited applicability here, but it's something to think about because people tend to forget about it. This is an employment-based professional visa. So what we're talking about with H-1Bs is we're talking about individuals that possess a bachelor's degree in a specific subject that are coming to the United States to work in a specific occupation. So we're talking engineers, architects, licensed professionals, doctors, things along those nature. There are a variety of professions that fall into the H-1B category, but it is employment-based, so there has to be an employer. You can't sponsor yourself, so there has to be a separation between the individual and the employer for an H-1B. H-1Bs are also subject to statutory limits. This is called the H-1B cap, which has been the bane of every immigration attorney's March and April since I've been practicing, because that's when the cases have to be in. The cap is 85,000 H-1B visas. That's 65,000 for people who have a bachelor's degree, and another 20,000 for individuals who have a US master's degree. And all of those, everybody who wants to apply for an H-1B applies in the end of March, and a computer generates a lottery, and selected applicants, should total about 85,000. Last year, I believe the USCIS received, I'm going to get this wrong, but it was around about 400,000 H-1B visa applications on the online system. So that was in contrast to roughly 320,000 the year before. So certainly we've seen a massive uptick in H-1B applications. The chances of getting an H-1B visa are slim. Applicants who possess a US master's degree stand a much better chance. They essentially get 2 bites at the apple to obtain that. However, there are possibilities for individuals who work for organizations that are institutions of higher education, nonprofit entities, or nonprofit research organizations. They're not subject to the H-1B cap. So if a business is you're setting up a business that's tied to a university, sort of a medical practice or something like that, there is the potential for cap exempt H-1Bs, which is a great tool, because there's no time. You can apply whenever you want, provided you qualify. It's a great option for bringing over qualified workers. There's also a fair amount of rules on H-1B time limits. They're initially granted for 3 years. You have a maximum of 6 years in H-1B status. And much like we're going to be talking about Ls as well, individuals who hold H and L status actually share time. So time spent in the US in either status is counted in terms of your maximum time limit. So H-1Bs have a maximum time limit of 6 years. If you're spent some of that time in L, that also counts. But time not spent in status includes any time you're not in the US. So any time, any holiday, anything like that can be recaptured and added onto the total. There are certain rules for individuals to extend their H-1B status beyond the 6-year category. That gets a little technical, but it's basically people that have been waiting for a green card for a very long time, typically individuals from China or India. So one of the big visas that we wanted to talk about today that is appropriate is the L1A visa. So this is a multinational transferee visa that concerns managers or executives who work for a foreign company who are coming to the US to work as a manager or an executive. These companies, they have to have a qualifying relationship, which means they have to be connected. That could be a parent and subsidiary. It also could be affiliated entities, so essentially sister entities. Both companies, so you have your individual who's transferring, both companies that they come from and they're going to have to be active, and they have to be engaged in business. So throughout the time, because this is a petition, these are for the vast majority of Ls are petition based, you do have to have significant evidence that businesses are active for these kind of visas. The big qualification for L1A is that the individual's qualifying employment with the affiliated entity abroad has to have been for at least 1 year of the last 3 before they come into the country. So that position abroad usually should be managerial or executive. There's some limited allowance for individuals of specialized knowledge to qualify, but it's difficult. But when they're coming to the US for an L1A, they have to be going to a managerial or executive capacity. And one way that I like to differentiate between those is executives make the big time decisions. They're high up, high level, reporting to a board, reporting to themselves potentially, but very high level decision making, whilst managerial are managing either professionals or managing managers. That's probably the best way I like to summarize the difference between managerial and executive for the USCIS. L1A applicants, however, have a great benefit, and that is that they're eligible to apply for a specific green card after probably about a year in the country. The reason why we say probably about is, we'll get into this, but the business in the US needs to be generating enough income and enough profit to be supporting that executive or manager. One of the great benefits of the L1A that's the law actually recently changed on this is spouses can come with the L1A principal in L2 status and can work as soon as they enter the country. They have unrestricted work authorization when they enter on their L2 visa, which is that's the dependent visa for L1As. And yeah, they can take that I-94 record of coming into the country and get work, do whatever they want. Or dependents can also come in on an L2 as well, so kids. Also, yeah, L1As don't have to maintain a foreign residence. So there's no, some of the visas that we'll talk about ease specifically, there's foreign residence requirements that have to be maintained. No such thing for an L1A. Now, there is a provision of the L1A that covers new offices. So say you've been working for your business abroad, you want to come to the States, but you don't have an active business. You can still apply for an L1A, for a new office L1A or an entrepreneur L1A. Instead of showing that the US entity is active and engaged in business, you have to show that it's almost active and almost engaged in business. So we tend to find that this is initially quite a low evidentiary requirement, but when you only get that visa for a year, the next time when you come around to extending that visa for a full 3 years, the evidentiary burden is quite high. So I often caution my clients for the entrepreneurial L1A or the new office L1A that that business has to be ready to go. You really have to be up and running. If possible, I would prefer to steer clients to getting businesses that are pretty much ready to go. So up and running and going for a straight L1A rather than the new office L1A, because the evidentiary burdens can be quite high. Just briefly on the amount of time that you can spend in L1As. L1As have a maximum of 7 years. And that gets a little weird because you sort of apply for them in 3-year increments. So you have 3 years, and then 1 year. The reasoning behind that is the individuals will be applying for a L1A related green card after the second visa extension. So here are the steps: filing with a petition, picking up the visa, and then finally the person enters. It's fairly straightforward. So let's go into a quick scenario for an L1A. We're talking about Samir here, who has his country abroad and wants to come to the US to open a branch and continue business. So this is really what we're talking about. We have a foreign entity. The entity form is not important for the most part because entity forms can be different obviously around the world, but it has to be active. Then we're looking at a US office. Potentially the individual can come in on a B1 or come in for the entrepreneurial L1A. So looking at structures here, these are sort of some basic ideas. We're looking at a parent, a foreign parent to a US subsidiary, or we could look at affiliates that are both owned by Samir, but no direct corporate ownership between them. In that scenario, they're affiliated because he is the ultimate owner between all the businesses. Finally, this one's a little wacky, but it does work, that Samir could set up set up the parent in the US, open a foreign subsidiary, go and work at it for a year, and then come back to the United States. It's complicated, but it works. And I'm just going to briefly go over the L1Bs because it's probably a little beyond what the kind of clientele that you're going to be dealing with, but L1 organizations, provided they have the qualifying relationship, can transfer individuals over who have specialized knowledge of a specific service, technology, equipment, advanced processes, things of that nature of the corporation. They're a shorter time period, only 5 years in L1Bs, but if you want more information, reach out to David or I. Now, the big entrepreneurial visa that we want to talk about is the E2 visa. So an E2 visa is a treaty-based investment visa. This is specific to individuals or companies that share nationalities with a country that the US has a treaty of commerce with. Some of these go back hundreds of years. In terms of the E, a general rule of thumb is the individual has to be investing a substantial amount of business in a bona fide enterprise. So we're talking about something that is real. It might not be operating yet. It might just be, in the initial stages, but the capital transfer or the expenditure of investment funds has to have occurred, because that evidence of that occurring has to be presented to the embassy. There is a minor rule where you can put funds in escrow. Some clients like to do that. It's a little, it works. In terms of control, we're talking about the treaty individuals owning at least 50% of the US enterprise. So that could mean you have an E2 enterprise that's set up, say it's Irish owned, and 60% of the individuals are Irish, but only one person is applying for the E2. That's fine because the company is Irish owned. And the principal E2 investor has to be coming over to manage and direct that business. The principal investor can also be a company, so there is that as well. So here's a sort of scenario here for Sarah. She is buying a business as a individual who is a citizen of a country of which the US has a treaty of commerce. She wants to send herself over. So how does she send herself and other employees over? Sarah is French, so the employees that she wants to send over have to be French, and they're coming over as executives or supervisors. Now let's just go through that quick checklist here. There's a treaty between the US and France. It's a French company. We've got substantial investment that she's made and evidence of that. We've also got control of the US company and the viability. So, it is the business, the E2 business does have to be a real business, and demonstration of a secure or a bona fide economic plan has to be demonstrated at the embassy. So Sarah's transferring herself. What does she get? She gets an E2 visa that's valid for 5 years. That visa can be renewed indefinitely as long as the business is still in operation and is hiring US workers. Her spouse and any children can come with her in E2 status, and spouses can work. Again, that's the same change in the law that happened for Ls. Now, this is a bit of a weird disconnect with E2s, is the visa might be valid for 5 years, but status is only granted in 2-year periods upon entry. So, but every time you enter the country, it's valid for another 2 years as long as the underlying visa is valid. So one key difference between the L1 is that E2s don't directly lead to a green card. We'll talk about that in a little minute. Also, there has to be a substantial amount of capital, and that has to be commensurate to the business. So, if Sarah's just setting up a small office for maybe an architecture firm, she just needs some computers, that's a lower amount of business. What if the business is a coffee roaster or a glass manufacturing company, requires a lot of heavy equipment, a lot of substantial product, that's going to have to be a higher level, and the US Embassy will want to see that. And I think I like to just go through a couple of key considerations for ease. You have to consider that the profit has to be the game. This is not a subsistence visa. The embassies get very wary of E2s where there's no other income for the principal investor. And the capital investment has to be at risk. It has to be put into the investment, the vehicle itself. It's transferred over across into the US. And the investor has to demonstrate that they're skilled enough to run it, and their resume, plus also the interview with the embassy. They have to be able to show that they're willing and ready to go for this. And I think one thing that the embassies always look for is the plan must be to hire US workers. That's the whole point of the E2. Is it's businesses, you bring a business over, you're hiring people. Franchises are also really good potential E2 vehicles, because when you buy a franchise and you sign a master franchise agreement, you have all of that backing of the franchisor, so you can show to the embassy very easily, oh, well, I bought this McDonald's franchise, here's the McDonald's business model, it makes a lot of money. There you go, that would work. Now, E2s and L1As can work well together, because an individual could come over an initial E2, and then after a year, if provided there's a link between corporations, maybe they could transfer over to an L1A and then look at a green card possibility. So you want to work carefully with your immigration advisor on that one. And of course, approved E2 enterprises, you can bring over more treaty country nationals as you need them. And here's a big list of the E-treaty countries. Now, this is a list of countries that are all E1 and E2 certified, so there's no difference between them, but it gives you an idea of the kind of countries that we're looking at. Now, who doesn't have them? Unsurprisingly, top of this is Russia, but also China and India are the two big ones that don't have treaties. Brazil as well is a huge one. So some of them are in the works, but I don't think you're going to be seeing Russia on this list anytime soon. India, potentially, we'll have to see about that one. So just briefly, we'll go over the TN. This is for nationals of Canada and Mexico. Again, this is an employment-based visa for the most part. There are some exceptions for individuals who are management professionals, but they are specifically focused on professionals as outlined in what was previously called the North American Free Trade Agreement, is now called the USMCA, kind of like YMCA, but USMCA. The US takes a dim view of Mexicans in this situation and forces them to go to make visa appointments, whilst Canadians can just cross a border and obtain TNs very easily. Finally, on the non-immigrant visa category, you have the O1 visa, which is an extraordinary ability visa. So this is a very interesting visa category that I think gets overlooked often because it is reserved for individuals who can demonstrate extraordinary ability in their field. It is employment-based, but it is designed with flexibility of employment in mind. So if the employer is partly owned by the O1 principle, that's allowed for O1 visa applications. But the bar to entry is the high petition requirements. So there's got to be a lot of supporting evidence that the person is a leader in their field of business, for example, and that can be demonstrated through media, through letters of support, publications, you name it. It is a great option. It's a little funny because initial O1s are valid for 3 years, then it's 1 year increments, but presumably individuals who come in for an O1 will later move on to a extraordinary ability green card. So immigrant visas, we're talking about green cards here. So there is essentially one large pot of green cards that's opened up every fiscal year. We just started the fiscal year a few days ago on October 1st. Green cards currently are in a strange place because of the backlogs experienced worldwide due to the COVID-19 pandemic. All the embassies stopped issuing family-based green cards. So we had when family-based green cards aren't issued, they flow over to employment. So we had a big boost in employment green card numbers. That will probably drop off for the next fiscal year and then again. But if you weren't interested in the figures of how it works out, that's how it's broken down. And then it's broken down by country as well. So it's quite an interesting system. But yes, moving on with our immigrant visas, number one is the EB1 visa. So this is the extraordinary ability flavor of the O1, but as a green card. So the big difference between O1s and EB1s is you do not need an employer. Applicants can self-petition. They just have to attest to their intent to work in their field of endeavor in the United States. And an employment offer is great. It's great evidence. We encourage it, but it's not required. Now, David, do you want to talk a little bit about EB1s here?
Sure. I think EB1s are a type of visa that is often overlooked because people are not, frankly, aware of them, and are particularly important to your client base because people who can afford to buy property in Hawaii are often people who have extraordinary professional backgrounds and may be eligible for the EB1. We've seen situations where we've done many EB1s where the husband or wife comes over in the EB1, brings the entire family, and the process is fairly quick because you can do premium processing. And then the primary applicant still has the option of going back and forth to run their business overseas. But of course, it's an immigrant visa, so they have to establish that they are living here. But it's an extraordinarily helpful visa for people who may not even know that they can self-petition. And so that when you talk to your investors and you get to know them and know their background, it may come out that they have an extraordinary career. And EB1 should be, if they're interested in a green card, the light should go on and go, EB1, go see a lawyer. So It's a very, very effective visa. But of course, it's really reserved for people who have a long background of success in different fields. We've handled them in various different fields. So I just wanted to mention why we feel that this is something that is of particular importance to your potential clients.
Yeah, and absolutely. And also, don't forget the O1A as well. If they are, have this great record, this great career, potentially an O1A for a business they set up that can self-petition them or petition for them, potentially coming on the O, then you transfer over to the EB1. So that's something to bear in mind. It's a great potential option. So the other sort of variation of the EB1 is the multinational and executive flavor, which is the EB1C under the Act. So this is the green card development of the L1A visa. So a lot of the same requirements are in place. A lot of the regulation and law is actually identical. So it's the same principles. You have a petitioning US company. You've got the same affiliate relationship between where the person was worked abroad and where they're working in the United States. Now, you don't have to worry too much about when the individual, applying within 3 years of the person entering the country, because they look at the preceding years before entry. So basically, if the person qualifies for an L1, they'll qualify for the EB1C. Again, it's only reserved for multinational managers and executives. We tend to find that the USCIS does put a bit of a higher bar here for EB1Cs. They really want to see that the business is making substantial profit. It's grown, it's got US workers. They seem to have an axe to grind with small businesses in this regard. And pretty soon, it's not quite yet, we're sort of working, the USCIS is slowly working there, but pretty soon EB1Cs will be able to obtain their immigrant visas via premium processing. So that's a 15-day calendar processing time for EB1Cs. We think that will be, live for new applicants probably in the next 2 to 3 months, I think, which is exciting for a lot of our clients. So little scenario here, we've got Samir again. He's coming on his L1A and he's like, oh, wow, I rather like it here in the US. So he's got his subsidiary running and he wants to stay here. So, it's the same. We're looking at that same foreign parent US subsidiary. Obviously, when you're looking at an EB1C, it is always the US company that has to file. That's just the requirements for permanent employment immigrant worker petitions. So what's the benefit here? L1As, yeah, so exactly. Why would you apply for an L1A if you potentially qualify for an EB1? I think the main one here is just logistics. L1A petitions, you can get a premium processing answer in 15 days, and then a visa appointment straight after that. Conversely, if you're looking at EB1Cs, potentially soon we'll have premium processing for EB1 executives, but even then, that visa appointment is an immigrant visa appointment, and that's much more onerous in terms of wait times. So L1As get you in quickly. Certain embassies have cut their L1A wait times to less than a week. I had a client who booked his appointment and wasn't able to get there in time because it was the next day. So, they really have sped up with the embassy processing here. Also, L1As can be filed for startups. EB1Cs, however, you can't be filed for startups. They've got to be established businesses. So, if someone's coming over with their entrepreneurial L1A, they're going to have to wait at least a year. I recommend for the next tax year to be able to show, and potentially you don't want to waste a shot at an EB1C if the business isn't up and running enough sufficiently. You want to make sure that the evidence there is built up. So business activity is really important. Okay, so what if I don't have a business? What if I've just got a degree? So there are some options. EB2 is an immigrant worker petition for individuals who have an advanced degree. So say I've got a master's in architecture and I work for a architecture firm, they could sponsor me via the Department of Labor's PERM system to demonstrate that there are no qualified US workers to do my job. Obviously, I have to possess the advanced degree and have a bachelor's degree and substantial experience. And then the employer has to go through a curated process of obtaining a wage for my position, and then various forms of recruitment to demonstrate to the Department of Labor that there's no qualified US worker in the regional area that could do my job. So this PERM, as we call it, it's the name of the electronic system they use. This is kind of the timeline. You're looking at, it's pretty substantial. They're taking, I would say, the Department of Labor has gone much slower on these recently. You know, we're looking at wage requests that are taking 7+ months. Recruiting and advertising usually can be done within 2-3 months. PERM processing averages between 6 and 9, and then only at that point, once the PERM is complete and there hasn't been an audit or the Department of Labor isn't happy with it for some reason, only then can the individual change their status to that of a green card holder, and that application process can take 14 months. So, you know, the PERM isn't quick. That's just unfortunately the way of things, and you need an employer. You can't, it is very difficult to sponsor yourself or have the company that you own sponsor you for a PERM. It requires specific disclosures to the Department of Labor. In certain circumstances, they'll approve it, but it's very tricky, and you want to talk to an attorney before you attempt it. Well, what about just skipping it? That sounds like all these recruitments and wages sounds like far too much work. Just skip it. Fine. So the option is the national interest waiver. Now, I don't think national interest waivers, Dave and I were just talking about this, really don't get enough play, and they should. National interest waivers are immigrant visas where the individual demonstrates that they have a proposed endeavor in the United States that has substantial merit and national importance. Then they have to demonstrate that they're qualified enough to carry on this task, do it effectively, and that on the balance of everything, it's better for them to do it than someone else. So to avoid the labor certification, the PERM process. The big thing with NIWs is there is no employer requirement. You can do it yourself. It can be a self petition. Now, if the individual doesn't possess an advanced degree, you know, you have to show specific evidence to prove that they're at that extraordinary level to then advance into the national interest waiver. But for most individuals who we're looking at for NIWs, that doesn't tend to be an issue. But NIWs, you know, when you think about what has national importance, what has substantial merit, again, we're looking back at the individual's career. You know, what if the individual has a substantial career in academia or business in a certain specific area, and they want to bring that to the United States, but maybe don't have a specific concrete plan? You know, an NIW could be the way to go. It is something, you know, if you think about your tiers of visa lists, oh man, you know, you're talking to someone, they had this great career, well, maybe an EB1 or an NIW, you know, it sounds like what you're doing is really worthwhile. What if the person has, you know, substantial public interest in public interest angle of what they do, but maybe they might not qualify for an EB1A? Hey, you know, an NIW could be a good option. And recent changes in the law have really opened the avenues for economic national merit and substantial importance. So economic factors can be considered for NIWs. So, hey, what if he wants to bring his entrepreneurial angle to a certain part of the country? You know, hey, that could be really good evidence for an NIW. And then finally, we're on to the big one of the immigrant visas. This is the EB5 visa. So this is the investment green card, if you will, the subject of continued debates, and especially during the last administration and the fallout from the last administration. The EB5 visa was under a significant amount of flack, including several different court cases. All of those have kind of cleared up. We've had legislation passed regulation passed to really secure the EB5 and its future. It's not going anywhere anytime soon. I think its fate is secured now. but we have new investment totals. So the main thing for an EB5 to remember is you're looking at an investment in the United States of 1,050,000 or 800,000. Now, the difference between those two totals, the 800,000 is the lower investment total is for investment in economically underserved areas, rural areas, or infrastructure projects. Whilst if you're just investing in a business with just, without one of those modifiers, it's just, $1,050,000. But the investment has to create 10 permanent full-time jobs for US workers. So there are sort of two flavors now of EB5s as well. So there is a direct route. I'm investing, I'm making my business. We're going to hire 10 people. I'm putting my money. I'm going to demonstrate it to the government, and I'm going to direct it myself. That's fine. The other option for the EB5, which I think is why it's so popular, is it can be a passive investment visa. So in those regards, the latest developments in the law have basically put every EB5 that isn't, just one person investing in one business has to be part of what is called a regional center. Now, regional centers are a great idea and started around 2000-ish when people realized the EB5 visa wasn't really going anywhere, as a method to pool investment resources. So EB5 projects include, high capital expenditure projects. Hudson Yards in New York, for example, the whole development of the Hudson Rivers and all of those buildings and everything, and all the workers that all those buildings include, was partly funded by EB5 visas. And it pools investors' resources. So, you could get a class of 100 EB5 investors all putting money into, divvy up the 500 jobs that Hudson Yards creates, for example, to use that one as one of the examples of EB5 projects. However, there's risk. EB5s, generally speaking, are risky visas, just because it's a financial issue. The terms of the agreements, a lot of it, as attorneys, we can't really advise on, this one's better than that one, or that is a financial due diligence approach that you really need to be careful with when you're looking at potential EB5 regional centers to invest in. Some of them are really great. Established track records are one good thing to think about. And then the steps of an EB5 here is just looking through it really quickly. It's a petition process. So you want to find the correct investment vehicle, talk to them, then you want to come take that to an attorney to verify, and then you go through the various steps of initial application, and then entering the US as a conditional resident, so you sort of enter to come in, you spend 2 years in the US in conditional status, then you apply to remove those conditions by proving that you've created 10 full-time jobs with your investment. Yeah, go for it.
I wanted to just follow up on that. EB5, from the types of investors you have, is the most recognizable visa. Everybody knows the EB5, and they assume, that's where long-term we're going to get our green card. We, want to buy the property and rent it out or whatever. But long-term, if we want to live it, it's the EB5. The message that I've been repeating all these years and repeating once again is that should be the last resort. When you have highly skilled, successful investors with an amazing past professional experience, there are visas that don't require $1 million or more of investment, that don't require you to find a regional center or an employer, and just are based on your own credibility as an amazing professional. And again, that's the important thing that we're trying to convey. We're covering all these visas, and the EB5 is, of course, the most popular or the best known, and sometimes it's the only option. But we're also saying that there are other options, and the message to your investors is, don't jump to the EB5 before you at least look at these other options, especially if you have an amazing background.
Yeah.
I'm going to turn the computer back to Michael.
Sure. Yeah.
And guys, we want to leave a little time for Q&A as well.
Yeah, we're just wrapping up. I just want to
All
put
right.
in one key thing about EB5s, and I think it goes to the international part of this because a lot of investment resident programs that exist globally, don't have a 10 full-time worker requirement. They don't have a lot of the restrictions that the EB5 has. I forget what Grenada is like 80 grand or whatever it is, or 120. It's just you just write a check. That's not what the EB5 is. It has substantial requirements, and it's passive, but it is the hardest route. It takes a long time. And yeah, there's sort of some basic outlines here for you to look at on EB5s.
But
we've talked about.
Yeah, but let's leave the, I'm sorry, there's so much to talk about, but let's leave the rest open for questions and interaction.
Okay, great. Well, thank you very much for all that. And yeah, we've got a couple questions. Let's start with this one. Is Hong Kong now considered People's Republic or mainland China for immigration purposes?
I believe that Hong Kong nationals are considered under mainland China for immigrant visas, but they have exclusive processing for the embassy there.
Okay. Now this you may not know, this is a question actually about a US citizen traveling to China or Asia, where it's combining both business and pleasure. Which would you select? Which do you recommend to select? And then alternatively, maybe when people are coming to the US, is it better to check on that as pleasure or business, or does it have an effect?
Generally speaking, with all interactions with all immigration officers globally, I will always be completely upfront and honest in everything that you write. So if you're coming for business, say you're coming for business. If you're coming for to visit for tourism, just tell them. If they want some more information, have that on hand. But you don't want to get into the business. You don't want to get into the into saying anything that could be slightly considered inaccurate when dealing with immigration officers.
And I think for people who come, say, to Hawaii, there may be a combination, business and pleasure.
Let me add to that, Patrick, that if they're combining it and they have, a really strong foundation in their country financially, it may be advisable to apply for a B1, B2 instead of coming on an ESTA visa, because it gives you a lot more flexibility. So that would be, I think I see people getting in trouble with the ESTA visa coming back and forth, and it starts to trigger. But if you have a B1, B2 that's good for 5 years, that could be a combination, then you alleviate that stress.
Because the customs and border officials in the US, don't have all they have is your travel records to look at for the most part, but they have all of them. So they will single people out if they think this person is traveling too much. They'll have you on the list to talk to you when you fly in.
Okay. And gentlemen, do any of the Asian countries require an advance US visa before entering as a tourist? I think this question refers to, do you just get a stamp at the airport, or do you actually have to go through a process? Say you're flying from Japan or Taiwan.
Most of the sort of Asian countries we're talking about, Korea, Japan, are covered under ESTA. And then an ESTA application is made very straightforward. It's a very straightforward application online before you travel. But when you get outside of those areas, then you get countries that aren't part of ESTA, and then you do have to get a B visa abroad before you come in. So
would ESTA refer to someone who is traveling here, say from Japan, as a tourist or a business person, something like that?
Correct. It's an easy tourist function, an easy business or tourist streamlined visa function, if you will, for key allied countries. It's a great option if available, because you avoid going to the embassy.
But there's a process before you come in order to online to do it. I think that was the question.
But not go to the embassy. It's just a process.
Correct.
Okay. Regarding the E2 visa or the business visa, If purchasing an existing company, how much money is needed to qualify? And I guess this would go to the substantial capital requirement.
Yeah. Do you want to take this one?
There is no definite or clear number. It depends on the nature of the business. However, machines aren't making decisions. Human beings are making decisions. So the more money you have to show that you're initially investing, or that you have to available resources to invest as your business plan takes root, the better. I mean, I would say you want at least to show 250 to 300. I mean,
Yeah.
but that's not written in stone. That's written in human nature.
Yeah, and I think you've also got to show that you're putting the capital in to make a profit. So it has to be a substantial profit, a substantial investment, and you need a good business plan to support it. So maybe you're like, oh, I've only got 150,000, but I've got tranches of debt financing and other stuff coming in. Hey, if it's coherent enough and it's a good case, the embassy would probably accept it. But I'm very wary on giving specific numbers because it is very business dependent.
Okay, and there's a couple of questions that surround this. This has to do with remote work. So if someone is coming from another country and they are remotely working in the United States, do you have any advice there?
That's a good one, and it's come up quite a bit. I actually ran a panel on it with the ABA, and there is no real controls here in the US, but you do if you come in on a B visa and you work remotely, work for your job abroad on the B, do you run afoul of the working without authorization rules in the United States? I think if you take a conservative view, you do. I don't think it's accurate because the work site is abroad, the payment of funds is abroad, all of that activity. But if you strictly look at the rules, potentially the person could be.
What would be an example of that?
Yeah, so say I work, I'm an English national, and I come over for 6 months on my B visa to go to Hawaii, but I continue working on my job in the UK remotely. I deal with the 12-hour time difference. Okay, maybe this is a bad example, but and then someone reports me to the immigration authorities for working without authorization. But I'm here as a tourist. I shouldn't be working. However, I'm earning income from my job abroad. There is no specific matter on point for remote work on tourist visas, I don't think.
And Patrick, let's play how that could play out. They travel again. They're called for secondary inspection, and they're going, oh, you were here for 4 months in Hawaii. How are you supporting yourself then? And let's look at your income, your bank statements. Oh, you were receiving money while you were in Hawaii. It can play out in those situations. So I agree that it's sort of a new area, but I wouldn't push it to months of doing that. If you're here for 6 weeks, I don't think it's going to come up. If you're here for 3, 4, 5 months, then it starts to become a question that could come up at secondary inspection.
Wow, very interesting. Going to one, you didn't talk too much about it today, but the F1 or the student visa. I think we see this often. Someone is buying a home here for the children to go to school. Do the spouses both have non-immigration status visas during that time? And how long can a student visa be used for?
Okay, well, let me explain how I've seen this played out. That a mom sends their child to Iolani or Punahou on an F1 visa, and then is basically living here with them and going back and forth on a B visa. It always ends up becoming a problem at some point. So one option for a family that's interested in sort of settling in their house, short term and then building for the future, is that one of the parents, let's say a working mom or a working dad or a live at home, mom or dad, they get a student visa, which includes the children on F2 visas. So that's a better option. Maybe they want to go into a higher degree. They have a bachelor's, they want to do a master's. That's a better option for the parent to get the F1 and have the dependent children than for the children to have the F1, and you risk being confronted when you're actually living in the United States. They do not really want parents living here overseeing their children in school. And I know a lot do it, but I think there are better ways to do it if the parent has a program that they could get an F1 on themselves and save them a lot of money if you have a couple of children. And it's also a way of testing the waters. If you're buying a house, is this a place that we really want to live in? That's the perfect time to sort of assess, is this a long-term place that we want to live, and then look for a green card.
Okay. And I don't know if you have an answer to this, but do most of the clients you work with coming from Asia, and again, we're thinking of our big countries, Japan, Korea, Taiwan, perhaps Hong Kong, do they want immigrant, or are they looking for non-immigrant visas? Do you have any feel for that?
I see both.
Yeah, I agree with that.
I feel that a lot of Asians, they want to, like I said, they want to test the waters really to see if this, particularly in Hawaii, but in general, but that they then move on to a green card later. That's
I'd say so. I think there are some, not to get too specific, but there are some nationalities that are always focused on, or some areas that are always focused on a green card. But I think, Europe, Japan, Korea, Taiwan, definitely the gradual non-immigrant to green card approach, ultimately citizenship tends to be a bit more the way they go. But some people want to go straight on in for that green card. Hey, it's but I think the gradual approach is what most clients tend to go for.
Okay. And relating to the L1A visa, can the purchase of an existing U.S. company and making it a subsidiary qualify?
Yes, basically. Yeah, it's actually quite good because all of that evidence from that business and I have to say it's in theory, based on limited circumstances, but yes, because it actually makes a great case for the USCIS, because you can show all of the business activity before the purchase as well. So,
and that applies also to the E2.
Mm-hmm.
I would add to that what a strategy would be showing how you're going to expand the business through a business plan. So it applies to both the E2 and L2, and it's a great way to go.
Yeah.
Great. Well, David, Michael, thank you very, very much for all the information. It's always a pleasure. It's always fascinating to hear all of this. And if anyone has any follow-up questions, you have clients, like I said, we've used the Garfield Law Group before. They're fantastic, total experts in your field. So thank you very much, gentlemen. That's going to do it for us today. So everybody out there, stay safe, happy selling, and aloha.
Aloha. Thank you. Mahalo.
See you guys. Thanks. Okay. Bye-bye.